All right, everybody, we're going to go ahead and get the meeting started. If you can please take your seats. This is a noticed meeting, and we are going to be taking public comment on the agenda. So if there is anyone in the public wishing to provide public comment on the entirety of the agenda, please make your way to the podium. Seeing none, this is going to close the public comment period for the boards and commissions and committees orientation and training. I do want to let everybody know that this is a recorded training and it will be available online after the meeting, hopefully later on this week or next week. This boards, commissions, and committees training is going to cover your role as a board, commission, or committee member. And I want to thank you guys all for coming today to either get a refresher on what you already know, or if you are a new board or commissioner, welcome and thank you for participating today. Just a reminder, again, there's water and chocolate at the top of the well. There are restrooms in the courtyard, or if you would like to use a restroom here in council chamber, over here on my left, there are restrooms, and also on the right. So today's topics include, whoa, I zipped right through those, didn't I? Well, the roles and responsibilities of a legislative body. We're going to talk about the Brown Act, Rosenberg's Rules of Order, conflict of interest code filers, and if time is allowed, hypotheticals and what boards and commissions might be experiencing at their board meetings. And part of what we'll be discussing on the Brown Act is what a legislative body, or what the Brown Act defines as a legislative body, meetings, agenda notices, and teleconferencing rules. So we're going to get right into it. Roles and responsibilities include understanding your role and scope of your board or commission, that you as a board member properly represent the board or commission that you're serving, that as you sit in your responsibility as a board member, that you're concerned with the entirety of the community. It's important that as a board member, you keep the lines of communications open with staff and your board members and the community, and be conscious of your relationship to city council and city staff. And on that point, we do want to remind board members that you do not have unfettered rights to give direction to staff and make requests of staff. You submit your information request to your staff liaison, and if the staff can work it onto an agenda or it falls within their work plan, it might be considered, but it does not give you, your role as a board member does not dictate the work plan for the city. Well, now the animations are working. My apologies. So again, regarding Council Policy 03, presentations to boards, commissions, and council members, as you sit in your appointed board member seat, please remember that no member of any board or commission or the city council shall appear before any body of the city of Santa Rosa representing a client or third party. And a member may represent themselves when necessary before a city body, but it does not apply to the sole practitioner who would be forced to refuse or represent a client or resign their office unless required by an applicable conflict of interest requirement. And now I'm going to turn it over to Teresa to go over some do's and don'ts for board members.
Hi, everyone. Thank you for coming. I'm Teresa Stricker. I'm the city attorney. And as Dina said, I'm going to walk through a few just general do's and don'ts that really help make sure that your board or commission runs smoothly and effectively, and that you're really able to do the job that you have been asked to do and appointed to do. So first and foremost is to do your homework, review the packet that comes out, review the agenda, familiarize yourself with the materials that staff has worked hard to push to you. If you have any questions after reviewing your packet, it really helps us if you can raise those questions in advance. That helps us maybe get answers to your questions, or to maybe explain something if there's confusion. You can certainly ask that same question at the meeting if you feel like the public would benefit from that. But oftentimes, if you give us a little bit of notice, we can get you more information than if you ask for the first time in the meeting. We, of course, do our best to get you the information, but it is easier, again, if we know in advance what your concerns or questions are. And that goes along with the third point, which is really to consult with your staff liaison, or if it's a legal question, with the attorney in the city attorney's office who is assigned to work with your board or commission. If you have a question, but also if you think you might have a conflict of interest. I always like to say that we would much rather you ask us the question and then have our office tell you, nope, you're good to go, than to do the opposite of that. So if you aren't sure, that's time to ask the question. Also, if you're not sure what constitutes a conflict of interest, if you got the training but maybe felt like you didn't quite understand, that's also a good time to reach out to your staff liaison or to this attorney assigned to your board or commission. And again, it's always good to avoid surprises if you can. It just goes back to if you know you have a scheduling issue, if you know you have a conflict, if you have questions, the more you can anticipate that up front, I think the easier it will go. That said, we do realize that oftentimes questions come to mind in the middle of the meeting, and so we encourage you to go ahead and ask them. But if you do know in advance that you have that question, please reach out. Also, really remembering that you are an individual on a body, and really remembering that you are a member of the whole, and the whole really represents the city. So even if you are appointed by a council member who sits in a certain district, or you really, in some instances, we have boards and commissions that are really focused on a particular district, just remember that in your role, you really are representing the city as a whole. And then really watching out bumping into another body. Sometimes we have issues that come forward to come forward to a variety of different bodies, and they may overlap. And so if you aren't sure about sort of where the jurisdiction is for your body, and making sure that you're not sort of bleeding into the jurisdiction of another body, that's time to ask a question. And then some of our boards and commissions sit not just as a legislative body or an advisory body, but as a quasi-judicial body. And so the Planning Commission is one really good example of that. And in a quasi-judicial capacity, that's really where the board or commission is sitting almost like a judge, and really making a decision about, for example, an application for an entitlement, or potentially an appeal from a decision. And when you're sitting in that capacity, just remember there are some extra legal requirements that apply, that really require you to do some extra things. And we will get into that a little bit later, but know that if you are sitting in a quasi-judicial capacity, you may need to recuse communications you've had with third parties, whether that's the applicant, maybe some neighbors who are in support of or opposed to a project, or if you took a site visit. So if you are sitting on one of those bodies, just keep that in mind, and keep in mind that, doing extra research could have some implications for your ability to rely on that kind of information when making decisions as a quasi-judicial body. Okay. Next slide. Okay, there's some more do's, which are actively participate in all of the matters that come before your commission. Try not just to pick the ones that are you find to be the most interesting. If you are in a body that makes recommendations to council, try to think through the long-term and the ripple effects of your decision and your recommendation, because certainly that's something that council will need to do as well. We also ask that all of our boards and commissions really make a commitment to civility. This is really the golden rule. Please treat others as you would want them to treat you. There are lots of sayings here about, one bad apple can spoil the whole bunch. So truly, you want to set the bar high. If others choose not to join you, please don't sort of stoop to the lowest common denominator. So really remembering the golden rule is increasingly important these days, where I think people tend to forget that. Please participate in training opportunities that come your way, and certainly participate in all legally required training opportunities. That includes ethics training, harassment prevention training, and this training. And so thank you all for being here and for your commitment to training. And then finally, if you know you're not going to be able to attend a meeting, please advise staff as early as possible. Sometimes your absence may be the difference between us having a quorum and us not having a quorum, and it may mean that the meeting needs to get rescheduled. Next slide. So there are some don'ts, and some of these don'ts are the flip side of the do's. Don't fail to show up if you haven't already notified staff that you'll be absent. Obviously, emergencies do happen, but we try to make sure that if you can be there and are planning to be there, that you actually show up. Sometimes folks who don't show up at the last minute, we end up with a lack of quorum, and we have other members of your board and commission that did take the time to show up, and members of the community as well. So thank you in advance for doing what you can to schedule around your meeting schedule. Don't fail to prepare. Again, please try to do your homework. Don't dominate or pontificate in the meeting. Really making sure that all of your colleagues have an opportunity to weigh in and ask questions and present their views, even if you don't agree with them. Don't appeal to the audience or to the media. This is the time to really focus on doing what's in the best interest of the city, and folks will have different views about what's in the best interest of the city, and that's okay. This really isn't a platform to really make media appeals. Being mindful not to cut off or interrupt others. We want to be respectful, and everyone will have the ability to present their views. And then again, this goes back to the golden rule, treating all others, whether that's staff, your colleagues, members of the public, an applicant, with respect. And it looks like we may have a kind of an embarrassing typo here where it says treat others with disrespect. So we will get that corrected before we upload. Okay. Oh, these are don'ts. Okay, so these are don't treat with disrespect. Yes, okay, phew. Okay, all right. More don'ts. Don't commit to a position before the meeting. This applies especially in those quasi-judicial proceedings that we were talking about earlier, where all decisions need to be made based on evidence in the record. So again, if this doesn't apply to you, this is less of a concern, but being open to the views of your colleagues is always an important thing, and usually makes for much better decision-making. And then don't pressure your colleagues to take a position before the meeting as well, for all of the same reasons. Again, be careful not to tell others they're wrong. You can agree to disagree, you can have different viewpoints, but no one viewpoint is the correct one. Be careful about criticizing staff in public. Staff works very hard. We have a very diligent staff, often who are balancing many, many, many tasks and are doing their best. And so if you could be respectful of staff, and if you do have some constructive feedback, oftentimes that doing that outside of a public meeting is usually a preferable way to handle that. So we appreciate whatever constructive criticism you do have, but again, if you could be respectful in delivering that. And then finally, don't engage in a back and forth with members of the public during public comment. That is really the public's time to communicate. It's kind of a one-way communication. While a simple point of clarification, if you didn't hear or you weren't quite sure what was said, would be appropriate, but engaging in a back and forth is not appropriate. It could, if we're during open public comment on an item not on the agenda, it could arise to the level of a Brown Act problem if we now have board members who are communicating back and forth about an item not on the agenda. And it also will impede your ability to get through your agenda and make others feel like that it is eating up their time to give public comment. And so really remembering that public comment is the public's time to communicate to you and not the other way around is an important rule.
Thank you, Teresa. Now we're going to talk about, in more detail, the conduct of a board or commission member. As Teresa mentioned, we have a number of policies that speak to the conduct of a board or commission member that we'll step through. First, we have Council Policy 51. It's the code of conduct for council members and boards and commission members. And it was developed to establish a framework for day-to-day actions and decision-making by council members and board and commission members. Ultimately, it increases public confidence in city government. It assists council members and board and commission members with decision-making, and it encourages a high standard of behavior by council members and boards and commission members. Specifically in subsections, and I'm going to quote this because it's quite a long passage. Specifically in subsections B4 and B6 of the policy, it states that council members and boards and commission members shall fully participate in council, board, or commission meetings and other public forums while demonstrating respect, consideration, and courtesy to others, and be responsible for the highest standards of respect, council policies, civility, and honesty, ensuring the effective maintenance of intergovernmental relationships. Just so you know, there's a handful of copies of this policy at the lectern at the top of the well. It can also be found at srcity.org on the right-hand navigation panel. Next, the city has adopted a commitment to civility document, and it was prepared, again, to assure civility in its public meetings and sets forth adopted rules of decorum to be followed at council meetings and boards and commission meetings and implemented by staff at other public meetings as hosted by the city. In this document, the city council and city staff seek to create an atmosphere of respect and civility, and specifically to establish and maintain a cordial and respectful atmosphere during discussions. And then there's more. The Guide for Advisory Bodies provides guidelines for members of city's various boards, commissions, and committees. It's not limited to just those that are advisory. It also includes Planning Commission, Board of Public Utilities. And it was developed for members of the city's various boards, commissions, and committees. It states that as an appointed member of a city advisory body, you are considered a public official serving in an advisory capacity or otherwise to the city council, performing a valuable service by addressing community issues and needs. And while the document addresses numerous aspects of the advisory body role, I want to point to page 11 of this document regarding meeting protocols and meeting conduct, and particularly to the following specific requirements for meeting conduct. Be fair and impartial and respectful of the public, staff, and each other, and give your full attention when others are speaking. Listen to concerns from members of the public, but refrain from engaging in discussion with public speakers, as Teresa has previously mentioned. Refer questions raised to staff to respond. Again, don't engage in side conversations or otherwise be distracted during the council meeting or your board meeting. And lastly, remember that your body exists to take action. It is not simply a discussion group or a debating society. So I've just named 3 policies that highlight the code of conduct for a board or commissioner. Generally, we don't have issues with conduct of a board or commission member. However, it has come up in the past. So much so that council has adopted also the open government section of city code. And it covers, or it assures civility in its public meetings, establishes and maintains a cordial and respectful atmosphere during discussions. Council and the community elevated the importance of these procedures and adopted protocols that we've just discussed in the ordinance to the effect that it states the City of Santa Rosa embraces a culture of open government in an effort to ensure the public trust, engage the community, and establish a system of transparency, public participation, and collaboration. So in order to meet the city code requirements, it is important for all city boards and commission and council members to ensure inclusion and participation in the decision-making process, ensuring the comments made by the decision maker is not exclusionary or dismissive. So that's 4 different documents that speak to the code of conduct of how we want boards and commissioners to engage with our community and elevate how we create this community of collaboration and inclusion. And these were developed over time too. One was developed to address one issue, and then it came up in another format. Then we moved to the commitment to civility, and then they ended up codifying it into our city code to highlight the level of importance of how we want to comport ourselves with our community as a board and commission member. So beyond all the policies that I just covered on conduct of a board member, we also have more laws, policies, and guiding documents that direct how we facilitate a public meeting and engage with the community. There are state and local laws and policies that were adopted for the boards and commissions to follow. State laws like the Brown Act to ensure the public's participation in the decision-making process and transparency. For City Council, the city charter establishes the frequency of council meetings, and City Council Manual of Procedures and Protocols dictates the agenda order. And many boards and commissions have your bylaws or specific details codified in Santa Rosa City Code. And when no bylaws or codes are adopted, the board then defers to the City Council Manual and Procedures and Protocols. Again, the procedure and protocols is available at srcity.org/boards. And then this slide transitions us right into our Brown Act content. So the Brown Act equals transparency, and it was adopted in 1953 after a San Francisco Chronicle investigation in 1951 about how local agencies conduct meetings. And it was also a part of a 10-part series called Your Secret Government that identified secret meetings and caucuses were common. So much so that the League of California Cities and the reporter that drafted the article drafted a bill, and Ralph M. Brown, the assemblyman at the time, carried it through legislature to adoption. Ultimately, the language of the Brown Act includes all meetings of a legislative body of a local agency shall be open and public, and all persons shall be permitted to attend any meeting of a legislative body, except as otherwise provided in the chapter of the Brown Act. So the Brown Act applies to all legislative bodies at the City of Santa Rosa, including council members and even council members elect. It is an aid to conduct the people's business openly and publicly, and a reminder that agencies exist to serve the community. The Brown Act requires or ensures that a meaningful agenda is posted in advance. It limits discussion to actions or matters on the agenda. It requires that materials be made available to the public. It ensures that the people's place on the agenda and has a part that people have a part of the decision-making process, hence the public comment on agenda matters as well as non-agenda matters. The Brown Act requires a 72-hour noticing requirement for regular scheduled council meetings or board meetings, and if it's a special meeting, it's a 24-hour requirement. The Brown Act also ensures that meetings occur with properly noticed meeting agendas. Next, we're going to talk about legislative bodies. So what is a legislative body? It's a standing committee of a legislative body, irrespective of their composition, have either continuing subject matter jurisdiction or a meeting schedule fixed by charter, ordinance, or resolution, or a formal action of the legislative body. And a formal action is defined or could be an authorization given to the agency's executive officer to appoint an advisory committee pursuant to agency adopted policy. And even if it's comprised of less than a quorum of a government body or governing body, a standing committee is subject to the Brown Act. So that we have a number of city council standing committees or subcommittees that are Brown Act meetings, like our Public Safety Subcommittee or our Long-Term Financial Policy and Audit Subcommittee. What is not a legislative body? The exception outlined in the Brown Act is a temporary advisory committee, also referred to as an ad hoc. A temporary advisory committee or an ad hoc are limited to a single purpose. They are not perpetual. They dissolve once a task is complete, and it is comprised solely of less than a quorum of the originating body. This might be something like an ad hoc committee to discuss traffic congestion. Now I'm going to turn it over to Teresa to discuss the Brown Act meetings portion.
Thank you, Dina. Okay, so what is a meeting? Well, a meeting is any congregation of a majority of the members of the body. It can be formal or informal. It can be planned or unplanned. It can be in person, through technology, or through intermediaries. It can be communications that occur one at a time or in a sequence. And it can be discussion or action. I would probably be able to go on a very a nice shopping trip if I could count the number of times over my career that I have been asked the question of, well, we're not taking any action, so it's okay, right? So who knows the answer to that question? It's not. It applies whether you're taking action or you're just talking about it. And the reason behind that is that we all know that a series of discussions can lead to action. And so the public has a right to really be part of the whole process, not just the last chapter in the book. And so whether or not you're taking action, even if you're an advisory body, even if this is just an informational item, the Brown Act still applies if all of the other requirements are there. So their notice requirements differ if it's a regular meeting versus a special meeting. And so for regular meetings, the Brown Act requires a 72-hour posting requirements. Here in Santa Rosa, we do require our council regular meetings to come a little with more notice than that. But for all bodies other than the city council, the requirement is 72-hour posting for regular meetings. For special meetings, that is reduced to 24 hours, and that's true for council as well. There are other types of meetings that occur in very prescribed and limited circumstances. There can be emergency meetings. Typically, emergency meeting is really truly an emergency. There are specific statutory requirements, and it can happen faster than 24 hours. If you're thinking that your circumstances is an emergency meeting, it is time to talk to the city attorney's office and to the clerk. There are very narrow circumstances. Okay. It includes informal meetings. Well, what is an informal meeting? An informal meeting can happen in a variety of ways. It can be for a 7-body member. It could be board members A, B, C, and D go decide to grab a cup of coffee before a meeting or after a meeting, and they're talking about business or items within the subject matter jurisdiction of the body. That could be an informal meeting. If you're talking about wine and cheese, you're probably okay. It can include what is called a hub meeting, and a hub meeting is where you have A call B to discuss an issue again within the subject matter jurisdiction of your body. Next, A then calls C to get that member's thoughts too, and then finally A calls D. If you've counted to 4 for a 7-member body, we now have a problem. Okay. It also includes a serial meeting. A serial meeting is a sequence of meetings. So again, if we're talking about a 7-member body, we have A text board member B to discuss an item again within the subject matter jurisdiction of the board. B then calls member C about the same issue, who then calls board member D about the same issue. So again, it's a sequence of events. And a series of communications of any kind, that the way in which you're communicating doesn't matter. The Brown Act doesn't care, whether it's an in-person, whether it's an email, carrier pigeon, text, however the communication occurs. If you can trace the communication and you've counted up to a majority, you have a potential Brown Act problem. Again, it includes all electronic communications. Be careful about replying to all in your communications. So if you receive something from staff, staff has emailed the entire board or commission, you have a question, please try not to reply to all. If you reply to all with your question, you could potentially have an inadvertent Brown Act problem. Everyone makes mistakes. If it happens over and over and over again, you start to wonder, is this a mistake or is this not a mistake? And so really, if you can try to avoid responding to all, you can avoid that problem.
Additionally, that is why you might see many communications from your staff liaison or recording secretary to themselves, and you are a blind carbon copy or the BCC on your email line. It's to avoid a Brown Act violation.
And oftentimes you may also see at the beginning, please do not respond to all, and that's why. Okay, next slide. So what is not a meeting? Individual contacts or conversations between board members and staff. Again, you have to be careful not to have a serial meeting. So if a staff member is meeting individually with each member of the board or commission, that's fine. But of course, staff would need to be careful not to convey the viewpoints and concerns of other board members to each of you so that you add up to really hearing what 4 members, a total of 4 members have to say. It's important to know that can also happen with members of the public. Remember, you could see a scenario where a concerned member of the public wants to meet with all of the board members to express concerns. That member of the public is not subject to the Brown Act, may not understand the Brown Act. And so it really is up to you if you're starting to hear about from that member of the public about the viewpoints of your colleagues. It's really up to you to sort of say, hey, we need to be careful. I need you to tell me about your concerns. Don't tell me about what my colleague thinks. And so really remember that in that case, you really need to guide the conversation to avoid an inadvertent Brown Act violation. What else is not a meeting? Attendance at a social or ceremonial event, a ribbon cutting, a retirement party, a wedding, with a proviso that a majority of the board or commission does not discuss matters within the board's subject matter jurisdiction at that event. So if you find yourself seated at the table with your colleagues and you count to 4 out of 7, if it's a 7-member body, you have to be very careful not to discuss anything within the subject matter jurisdiction. I usually suggest when you know you're going to be in that situation that you think ahead of time of things to talk about so that you aren't sitting there with the empty silence. It is awkward. We like to talk with our colleagues about the work we have with our colleagues. And this is a situation where you have to come up with something else to talk about. So your vacation, your children, your grandchildren, the dog next door, you name it, wine and cheese. So think in advance. And then attendance at conferences or other similar gatherings that are open to the public. there, you see there's that same asterisk, that's the same proviso that you still can't have a majority of you having a conversation about matters within the subject matter jurisdiction. So if you attend the League of Cities conference, I'll pick on the Planning Commission for planners, and they're talking about issues with ADUs. Obviously, that's a matter within your subject matter jurisdiction. Okay for you to sit there, okay for you to sit there and listen with a majority of your members. But what would not be okay is for you all to then, a majority of you, talk about the ADUs as a sidebar. So just remember that the Brown Act has exceptions. They're kind of practical common sense exceptions, but you need to make sure that you're still not having those conversations with the majority. Next slide. Open and public meetings that are not organized by the city that address a topic of local community concern are not a meeting. Again, with the same proviso, you can't meet with your colleagues at that meeting and chat about it. Attendance at a noticed and open meeting of another legislative body. So if you end up going to a city council meeting and it turns out that your colleagues are there and you count to 4 out of 7, that's okay. Again, you can't meet with them and talk about planning commission business. And attendance as an observer at an open and noticed meeting of a standing committee of your same body. So if you're in that situation, you could attend. But again, you can't engage in a conversation with the majority. Social media posts. This is a very, in my opinion, a little bit different than all of the other Brown Act rules. So this is one you want to pay special attention to. For a long time, there weren't specific rules. The legislature has now given us some, so that's the good news. But you cannot respond to the post of another member of your board or commission about items within your subject matter jurisdiction. No responses. So no emojis, no likes, no thumbs up. This is a special rule because it doesn't require a majority. Most of the time, most of the rules I've been telling you about, we have to count to a majority. So if you have a 7-member body, you have to count to 4. Here you don't. If you respond to a social media post of one of your colleagues, you have violated this rule. And so just remember that this is the special rule that it's okay if you read a social media post of your colleague. It's okay if the entire board or commission reads that same post, but you can't respond in any way. And again, a like is a response. Does that make sense? Okay. All right, back to Dina.
Now we're going to touch on agendas and notices. And this is a part of the Brown Act requirements. So agendas must contain a brief description of each item to be discussed, including items in closed session. Agendas must be posted hard copy and online and mailed to those who have filed a written request. And they must include a physical location accessible to the public and online 72 hours before a regular meeting or 24 hours before a special meeting. So you might notice for our boards and commissions, we have a posting kiosk here at City Council, City Hall, and we send out Gov delivery notices for all boards and commissions, or just about all boards and commissions. And then they are posted at the site where the meeting is going to be held. The agendas must be made available in appropriate alternative formats to persons with disabilities. We do that as requested. And then the Brown Act prohibits any action or discussion of items not posted on the agenda. The distribution of materials, it must be distributed to the legislative body and made available to the public at the same time of noticing. So when you as board or commission members are getting your council or your packets, staff is also emailing the public that Gov delivery notice at relatively the same time. So they'll shoot out your email with your agenda packet, and then within minutes, they are sending that communication out to the public so they have the information at the same time. Supplemental materials provided after the original posting or the final posting of the agenda must be made available to the public at the time they are provided to the legislative body. So just like we do for the final agenda posting, if a packet or a late item or late correspondence comes in related to your board or commission meeting, staff is sending it out to you, and then they're immediately turning around and sending it out to members of the public through that Gov delivery notice. Materials presented at the meeting must be made available to the public. So if a board or commission is holding a meeting and a member of the public brings in a copy of a newspaper article that gets distributed to all of the board or commission, we need to have a copy available for a member of the public to view as well. So if you know of a community member who's coming to provide you guys a document during a board or commission meeting, ask them to bring in the number of copies for your boards or commissions, 5 or 7, plus 2 copies, one for the community to view and one for your staff liaison to retain for public record. Actions not on the agenda should not be discussed. At a regular meeting, the legislative body, however, can act on an item not on the agenda if a majority decides that an emergency exists, and if 2/3 of the members determine there is a need for immediate action, and the need for immediate action came to the attention of the local agencies subsequent to the agenda being posted. And if this comes up where you feel the chair feels or the community wants to discuss an item not on the agenda, discuss it with your city attorney present or your staff liaison. It's used in a very narrow window. It doesn't happen very often. Public participation. The Brown Act requires that at all meetings, the public must be allowed to speak on each agendized item of business unless the item was previously considered at a public meeting. In addition, every agenda for a regular meeting must allow the members of the public to speak on an item of interest, so long as the item is within the subject matter jurisdiction of a legislative body. So as you're moving through your board and commission meeting and your agenda, if there is an item for staff briefings, you let them speak on your staff briefings if staff provided a briefing. If it's just a standing item on your agenda and there was no staff briefing, the chair does not need to open it up for public comment because there's nothing to provide comment on. And that includes staff briefings, department reports, member reports, if it's happens to be a quiet meeting agenda and none of your board members or commission members have a report. If nothing is reported on, no need to open it up for public comment.
I will add, however, that a member of the public could comment on that if it's a regular meeting and you have a time for open public comment of items not on the agenda. So they would either need to be able to provide it at the time when the agenda item is called, but it doesn't come forward, or they could provide it at open public comment. So there isn't anything that sort of then gets restricted and falls within that gap. That makes sense.
Another scenario that comes up during your boards and commissions meetings is permissible responses to off-agenda public comments. And it's at the discretion and direction of the chair or during the discussion after public comment where members of your board may either briefly respond at the direction of the chair, ask staff for clarification, refer the speaker to staff or appropriate reference materials, or ask staff to report back to the body at a subsequent meeting concerning any matter, or take action to direct staff to place a matter of business on a future agenda. So this is where, although we don't allow for the back and forth during public comment period, there is an opportunity for your chair to address those questions after the fact. Your chair and your board has the right to regulate public comment. The legislative body may adopt reasonable regulations regarding the public testimony. Most of our public comment periods are 3 minutes per speaker, but if you have a large volume of public comment anticipated, the chair, in discussion with your staff liaison, can make the decision to limit that to 2 minutes. In some instances, I've seen at other communities where they limit it to 1 minute. As an alternative to that, I've seen it where they have limited the public comment period to 30 minutes entirely for a certain item on their agenda. So those are some options to regulate public comment. The board chair may also stop a speaker who becomes overly repetitious or whose subject matter is outside of the board's subject matter jurisdiction. And lastly, the board chair may have a speaker removed from the room if the speaker disrupts the meeting after giving first a warning. And we'll go into that a little bit more. Now we're going to move over to Teresa for Brown Act violations.
So before we go there, I just want to, maybe if we can back up to the last slide, just talk a little bit about what is a disruption. So a disruption is not someone who just uses maybe colorful language that maybe we prefer that they didn't use, or that is speaking too loudly or vigorously. A disruption is really preventing the meeting from going forward. So it is really someone who is, for example, not abiding by the rules about when they can give public comment. They're not stopping as requested after their time is finished. They are not allowing other speakers to give public comment. It's really disrupting the meeting and not allowing the meeting to go forward. Why is that distinction important? Well, there are some people who may feel like, well, if someone is speaking maybe in a loud voice or is saying something that I don't like, that feels disruptive to me. And so we have to kind of balance, folks have a First Amendment right to stand up and make their comment. And so a disruption is really preventing the meeting from moving forward. And it's very important that we don't think about disruptions in the context of the content of what the person is saying or what their viewpoint is or who the identity of the speaker is. And so these are sort of just basic First Amendment principles that are important that we think about when we think about the term disruption. And so your staff liaison can help you with what to do in the case of a disruption, and certainly the city attorney who staffs your meeting can also help you with what you can do. Certainly taking a break, a recess, and sort of resetting is an important tool that can be used at any time if you're not sure either what to do or you're feeling like a disruption is happening. Okay, so with that, I'm going to talk a little bit about some Brown Act penalties. And so a part of, if a court were to determine, if there were a challenge under the Brown Act and a court were to determine that the city had violated the Brown Act, it could undo a decision, which could be, as you think about some of the decisions that our bodies make here, it could be a difficult situation, it could be a costly situation. So really making sure that we are complying with our legal obligations. In terms of, there's a cease and desist process, which I haven't listed here, that would come into play if someone were seeking forward-looking relief that we would need to navigate as well. And there is an award of attorney's fees. If someone is successful in suing the city and ends up winning, we would have to pay for their attorney's fees. So it can be a very expensive proposition for the city. There is a possibility also for intentional willful violations for a criminal prosecution and fines. I will tell you that that would only happen in a fairly egregious circumstance. But just know that is out there. It doesn't happen often, but certainly it is. We take seriously the transparency requirement of the Brown Act, and so really trying to do our best in order to comply is important for all of these reasons.
So the Brown Act also provides requirements or rules for teleconferencing and remote participation. There are 3 options if needed to participate remotely. There are the traditional Brown Act requirements for teleconferencing, and then there are 2 additional provisions under AB 2449 called the Just Cause provision and the Emergency provision. Traditional Brown Act requirements for teleconferencing include that you need to let your recording secretary know that you want to teleconference no later than 8 days prior to the meeting for the teleconference. Now, that's not a Brown Act requirement. That is a practical requirement for the city. We have to publish your address where you're teleconferencing from on the agenda, and it needs to be a complete address. The home of, or 1234 Happy Lane, Eureka, California, 12345. And it needs to be posted on the front door of where you're going to be participating from, or at the location of the hotel outside of the facility where you're going to be staying. It has to follow the same requirements of the Brown Act of being posted 72 hours in advance. So it must be published, you must publish the teleconferencing location on the agenda. The board member must post the agenda at the door of the remote location, which must be open and accessible to the public. The public must also be able to participate from the remote location. So if you are participating in your board and commission meeting under this teleconferencing requirement and you're at your vacation home, the notice needs to be posted at your vacation home 72 hours in advance, and you have to leave your front door open for the member of the public to walk in and participate at your meeting. You also have to make sure that there is at least a quorum of the members participating within the jurisdictional boundaries of the city. Remote participation under AB 2449 looks a little different. This is a need-based alternative for remote participation. The prerequisite is that a quorum must be present in person at one physical location within the city's jurisdictional boundaries. You may attend the meeting remotely under two circumstances as discussed, the just cause provision or the emergency circumstances. And under emergency circumstances, your board or commission must take action to approve using or applying the emergency circumstance provision. What's different about the need-based or the remote participation under 2449 is the board member is not required to identify their remote location or make it open to the public, but there are several additional requirements. Quickly, I want to define what just cause is, or how it's defined in AB 2449. Childcare or caregiving needs for a child, parent, grandparent, grandchild, sibling, spouse, or domestic partner. A need related to a physical or mental disability as defined by the statute. Contagious illness that prevents a member from attending in person, traveling on official business of the council or another state or local agency. Those are the qualifying reasons for just cause. And it can only be used 2 times a year. They recently amended this provision and defined it a little bit further. The qualifying reasons for emergency, it's defined as a physical or family medical emergency that prevents you from attending in person. Some additional rules under AB 2449. When you are participating remotely, you need to run through these criteria. A member must disclose whether any individual over the age of 18 are present in the same room at the remote location and state the general nature of the relationship with the individual. Again, it can only be used for 2 meetings per year if the body meets once per year, or pardon me, once per month or less, or a total of 5 times per year if the meeting body meets regularly twice per month or more. So staff is tracking that if you have to participate remotely. We're also tracking if you're participating under traditional Brown Act requirements as well. And then what's different about the AB 2449 provisions is that a member must participate throughout the entire meeting with both your camera and your video or your audio on. And this is different than what was happening during COVID, because during COVID, a member could participate with just their audio on and their camera off. In this circumstance now, under these provisions, you have to have both on. And what this does is it triggers remote public comment for the whole meeting. So if you show up to a meeting and participate remotely for a half an hour of it, but the meeting goes on for another 4 hours, your board or commission still have to take public comment via Zoom for the duration of the meeting. Now we're going to move over to Rosenberg's Rules of Order.
And Dina, if you don't mind, I'm going to just clarify just a little bit the number of times. It just if your board meets frequently, you can participate in a calendar year up to 5 times under AB 2449, but only 2 of them can be for just cause. So that means that you could do 5 for emergency circumstances if it's approved, assuming your board meets with that level of frequency. You could do up to 5, but you can total do up to 5, but only 2 can be emergency circumstances. So I'm sorry, just cause. So just know that what could happen is you could be told by your commission secretary that you sort of have run out of the ability to do it. And so, no, we are tracking that and that there is a cap. Okay, I'm going to talk about Rosenberg's Rules of Order. And so Rosenberg's Rules of Order has been adopted by council to fill in the gaps. And so Rosenberg's applies unless we have another rule that trumps it. So if there is a different rule under either the charter, one of the rules of protocols, a city ordinance, or frankly, state law, then that rule applies. Rosenberg's doesn't necessarily, so if we have a Brown Act requirement, even if it isn't square on with Rosenberg's, we still have to comply with the Brown Act requirement. Rosenberg's was really adopted, was created by a judge and adopted because Robert's Rules of Order was really created for a 100-person parliament, and it's quite a lengthy read. Rosenberg's is rather short and pithy and to the point, and really, I think a little bit easier for a city council or a board or commission to be able to be more nimble with. And so if you happen to be a Robert's Rules nerd, you probably get to the same answer. I have never heard of anyone getting to a different answer, although I wouldn't rule it out entirely. But if you aren't a Robert's Rules nerd, you don't ever have to become one because you can just read Rosenberg's Rules of Order. And I think you will walk away with all you need, and certainly all you need for your position here in Santa Rosa. Okay, so I'm going to walk through a little bit what Rosenberg's rules are. It really is a guide that establishes order and process and efficient meetings. Rosenberg's is really created to make sure that all the rules are clear, to make sure that the rules are user-friendly, and that the rules should enforce the will of the majority while protecting the rights of the minority. So it really is a balance to make sure everyone has a voice, but to be able to move forward with business and get decisions made. Okay. So quorum, the default rule under Rosenberg's is that more than half of the body constitutes a quorum, and a quorum is required for the body to conduct business. Our charter, our board commission rules, and our zoning code establish the quorum rules. So for example, for the planning commission, 4 out of 7 members constitutes a quorum. That's also true for the city council. A member who has recused and cannot participate in the matter is not counted to be present, and typically, we'll get into this in a little bit, will be required to leave the dais unless it's a consent calendar item, but they are considered not to be present and are not counted for a quorum. So if you have a bare quorum for a 7-member body, if you have 4 people present and 1 person needs to recuse, we no longer have a quorum for that item. What does that mean? Well, that means either we need to wait for another member to show up if someone is on their way, or that item can't be heard that day and it will need to be continued to another day. You can lose a quorum during the meeting. So I just gave you an important example of one. You can also lose a quorum if someone gets up to use the restroom. Again, if you have a sort of the bare quorum and you lose someone. If that happens, you can take a brief recess and wait for the person to return. If someone needs to take an important emergency phone call from home, you can think of all the reasons why you could potentially lose a quorum. If you lose a quorum and taking a recess doesn't solve the problem, then you need to adjourn the meeting, and the items will need to be continued until your next meeting. So it is important that you maintain a quorum. Without a quorum, we don't have a meeting and you can't proceed.
So Rosenberg's Rules of Order breaks down an agenda item procedure. It's more or less 10 easy steps. It's the friendly version of Roberts. So the item is called. At the appropriate time on the agenda, the chair announces that the agenda item to take up for discussion. And then there's some sub-bullets here that the chair asks for abstentions or recusals. For recusals, members must explain the conflict and then leave the council chamber or the boardroom chamber. The chair also asks for ex parte disclosure if applicable. This is mostly for quasi-judicial proceedings. And then the report happens in the presentation. So the agency staff member presents the overview of the item together with a recommendation to approve or deny the item.
How many people understand, raise your hand if you understand the difference between recusing and abstaining? What is the difference, if you understand the difference between recusing and abstaining? Just raise your hand if you think you understand. That's awesome. Okay. A recusal is where you have a conflict, or you might arguably have a conflict and you're recusing out of an abundance of caution. It means you can't participate. You have again, either a legal conflict or arguably a legal conflict or possibly a legal conflict, and you're going to treat it as if you have a legal conflict. That is a recusal. An abstention is essentially a choice not to vote. And so those are two very different things. And so there are requirements for disclosure. If you need to recuse, in order to recuse properly, you do need to disclose, and your commission staff secretary or the city attorney who's staffing your meeting can help you with what needs to be in that disclosure. For an abstention, you are welcome to give a reason for your abstention. There are council rules and policy that encourage everyone to cast a vote. You can't be forced to cast a vote, but we can certainly encourage you to do that. And you can give a reason if you choose to abstain, but there aren't really any rules about requiring a reason for an abstention. So that's an important distinction. If you are recusing, it's important that you follow the rules that staff will help you with to make sure that you are recusing properly. And then again, we talked a little bit about quasi-judicial versus legislative. If you are one of those bodies that's quasi-judicial, you will need to disclose those ex parte contacts that we talked about before. If you have questions about what that means, if this applies to you, we can talk about that offline, or you can ask either your city attorney or the staff who staffs your board or commission.
Okay, so the item's been called. Staff has made their presentation. Now, at the end of that presentation, the chair invites members of the decision-making body to ask questions to the presenter. And if applicable, the chair invites the applicant to give its presentation, invite members of the public, or invites members to ask questions of the applicant. That's, again, really specific to boards and commissions that hear public hearing items. Many of the bodies or the boards and commissions in an advisory capacity do not hold public hearings. After the questions period comes the public comment section. You open the public comment as the chair, you set the time limits for the speakers, you close the public comment section. Then you move on to a motion. That's step 5. Chair invites a member of the decision-making body to make a motion to approve, amend, or deny the item. You can use the staff recommended motion language. You focus on the substance of the desired action. At step 6, the chair asks for another member of the decision-making body to second the motion. Sometimes this is all flowing. It's not like the chair is going, okay, I need to go through, item 1, number 2, number 3, number 4, number 5. As you gain confidence as a chair, all of this is going to become second nature. So the second happens, and then the chair is to ensure that the body understands the motion on the floor. Many of your bodies or boards and commissions are discussing very complex items, and sometimes a board member may get lost in the conversation and not understand what is on the floor to be approved or denied. So it's the chair's responsibility to make sure the whole body understands what is being determined. Next, the chair invites discussion of the motion. At the conclusion of the discussion, you take the vote, and the body votes. Number 10, announcement. The chairperson or the recording secretary announces the results of the vote. This passes unanimously. This passes with 6 affirmative votes, with 1 council member voting no.
Okay, I'm going to talk a little bit more about the role of the chair. The chair is responsible, the chair or the mayor, in the case of city council. The chair is responsible for applying the rules of conduct to the meeting. The chair calls the meeting to order, manages public comment or public testimony in the case of a public hearing, facilitates deliberation, maintains order, and enforces rules. It is common for a chair to play a less active role in debate and discussion, but that does not mean that the chair should not participate. And typically the chair will allow other colleagues to go first before the chair then provides the chair's thoughts and deliberation. Along similar lines, typically a chair does not make or second a motion unless the chair believes that no other member will do so. Typically, you'll see that a chair will ask for a motion or ask for a second if a motion has been made. And then only if there is no motion or second coming does the chair usually jump in to go ahead and do that. Chairs, we've talked about this earlier, but chairs really should not allow back and forth with members of the public and should follow adopted rules and procedures with all of the sources that we've given you before. And then the chair will also address disruptions at the meeting, and the chair can certainly ask for assistance from the commission secretary or the city attorney there with assistance addressing those meetings. If you find yourself the chair and you're not really sure what to do, you can take a break. You can, ask staff to assist you. We can always take a break. So just know that you have that tool. Oftentimes that can also make the disruption kind of disappear, and we can reset when you come back. I'm going to go over a little bit about motions. Rosenberg's, again, if you want to take a look, it really outlines the different types of motions and how they work. A basic motion is what you all have heard and done before. I move that we fill in the blank. It requires a majority vote. Motion to amend. This is some version of I move we amend the motion and then fill in the blank. This is really takes that basic motion and amends it in some way. So it makes a change to the motion that was on the floor previously. Again, this requires a majority vote. A motion to substitute. This is a little different than a motion to amend. A motion to substitute, if passed, would remove the motion that is on the floor and replace it with the new motion. So I move a substitute motion and then fill in the blank. Again, this requires a majority vote. A motion to continue. I move that we continue this item. It can be to a time certain or not, depending on whether the item is one that required a particular public hearing notice. We may need to give it again if you don't provide a date certain at that point in time. And again, that motion requires a majority vote. Dina?
Another motion or term that is used under Rosenberg's Rules of Order is the phrase call the question. And it simply means to limit the debate that is being discussed for the item that's being discussed. The chair can ask if there's further discussion. If no, then you move to the pending motion on the floor. If yes, then the chair should treat the call for question as a formal motion. The chair should ask for a second, stop the debate, vote on the motion to limit the debate, and then motion to limit the debate requires a 2/3 vote of the body.
There's also a friendly amendment. This is really an alternative to a motion to amend or substitute, and it's really sort of a shortcut, informal way of getting there. I suggest a friendly amendment to the motion, and then you would explain what your friendly amendment is. If the maker of the motion and the person that seconded the original motion agree to the friendly amendment, then you have a new amended motion on the floor. If either the maker of the original motion or the seconder rejects the friendly amendment, then the original motion remains. The proposer of the friendly amendment can then formally move to either amend or substitute the motion. And so this is a really handy tool to have in your back pocket. It also is, not only does it shortcut it, but it's really kind of a collaborative way of asking your colleagues if they will agree to an amendment before you go ahead and make a formal motion to amend. So keep this one in your back pocket. Okay, a motion to withdraw. The maker of a motion can at any time, without a vote required, interrupt a speaker and withdraw the motion. The motion is then immediately considered withdrawn, although the chair may ask if any other member wants to make the motion. It could be any member, including the person who had seconded the original motion. Okay, next slide. Multiple motions. So you can see how there might be lots of motioning happening all at once. Under Rosenberg's, there can only be 3 motions on the floor at any one time. The reason for that is that after 3, nobody's going to be able to keep track of what the heck is going on, right? So it's a practical rule, and the chair should proceed with the motions first on the last motion received. So this is last in, first out, right? And so if we have 3 motions, 1, 2, 3 in that order, motion 3 would be taken first. If that motion fails, then we would move on to motion 2. If that motion fails, then we would move on to motion 1. If you are in the process of that elimination, there could be yet a 4th motion that comes up. And as long as you only have 3 on the table at one time, the chair can entertain 3. The chair could also choose to continue and resolve each of those 3 original motions before taking any more. So the chair has a little bit of ability to manage at that point.
Teresa, I have a question. If they can't get it done in 3, can they then so none of the 3 that were on the floor pass? Can they go to a 4th?
They can, at that point, you have no motions on the floor. Get creative. And it could be that you end up with the same motion being moved again, right? After resolving 3, people may have a different thought about what they want to do. And so the world is your oyster at that point. So you could have a 4th motion. You could, somebody could remove a motion that has already failed. A failed motion is a failed motion. You tried it, it didn't work. And so sometimes after that happens, people's views about what's going to work and where their position is might change, as you might imagine. Okay, voting. So what is required to pass a motion? In Santa Rosa and in many places, all city ordinances and resolutions require a majority of the entire body to pass. In the case of council, that's 4 out of 7. Most boards and commissions require a majority of the quorum for non-legislative actions. So what is a majority of the quorum? So if you have a 7-member body and 4 are there that day, you have a quorum, you can have your meeting. For non-legislative actions, you have to check the rules for your particular body, but for many of them, 3 out of 4 would pass a motion on non-legislative actions. That would also be, non quasi judicial actions as well. For legislative actions and quasi judicial actions, we would generally need 4 out of the 7 members. So you would need a quorum to pass. In the case where you only have 4 members present of a 7-member body, you would need all 4. So if you didn't get a unanimous vote in that case, you would have a failed motion. And so if you aren't able to resolve that, the item would need to trail to the next meeting or another meeting in order to try again when you have a fuller composition present. Voting options, yes, no, recuse, abstain. We talked about the difference between a recusal and an abstention. Keep in mind that if a member comes to the meeting late and they miss an item, we don't go back. They don't get to vote on the item that they missed. The item has already been acted upon. They just miss a portion of it, they can come in. It would, if you are dealing with a quasi judicial matter, that would be a different result because you would have missed potentially part of the public meeting. If you just missed a couple of minutes, staff could probably catch up pretty quickly. But just think about the Planning Commission. We have an applicant, we have folks, we're 2/3 of the way through the public hearing. I think at that point, if the Planning Commissioner came, unless the Planning Commissioner was able to say, I was stuck across the whatever and I was watching it the whole time and I got all of it except the last 90 seconds. I think if you were able to establish that, then you'd be okay. But you wouldn't really be able to take action on an item on a quasi judicial matter where you're making a decision based on all of the evidence in a record when you weren't present for it. Please keep in mind that sometimes those kinds of items continue to the next meeting. And so if you were absent for meeting 1, but you were going to be there for meeting 2, if you watch and listen to the whole item and you really did get to then see all of the evidence and hear all of the evidence presented, we would want you then, when you came for day 2 of the second part of that hearing, to just put on the record that you watched the meeting and watch the whole meeting, and so you understand what happened at the first part of the public hearing, so that we don't have a problem with someone voting on a quasi judicial matter having not heard all of the evidence in the record. There is a practical problem on non-quasi judicial matters. If you really are coming in, you've missed all of the staff's presentation, you've missed the public hearing, the public comment, you've missed the discussion, and you come in right before a motion is made and you cast a vote, there's an optics issue there that you might want to think about there, but there's not a legal requirement for that. So we don't do anything here that's judicial. We leave those to the courts. Yay. Quasi judicial is where you have, and I keep using the Planning Commission because that's probably our most frequent example, but council sometimes sits in a quasi judicial capacity, and there are other bodies that do as well. So if you have an applicant is coming forward with an entitlement, it's not about everybody. You're not passing a zoning amendment. We aren't establishing rules for the whole city. This is really about one applicant, one individual who has an entitlement, and we are making a decision about whether to either proceed with that entitlement or maybe it's an appeal. So they have the right to an appeal to either the Planning Commission or maybe to the City Council. And you're really at that point sitting, they call it quasi-judicial because it feels a little bit more like a judge. There's a requirement that you are making a decision based on substantial evidence in the record, right? And so your decision can't be based on things that aren't within the record. That's where you need to disclose those ex parte contacts, or if you went for a site visit, what you saw, what those contacts were, and state that your ability to make a decision based on what's in the record. So if that sounds like something that you're doing, please just reach out to your city attorney that's staffing your board or commission, or to staff to see whether this is something you need to be concerned about. If you're sitting on the planning commission or our newly comprised, and what is the new name of our design review called? Yes.
Design
Preservation
Review and
Committee,
Preservation Board.
that these are things that you are encountering on a regular basis. And so if you have questions about that, Ashley will be happy to answer. I'm happy to answer those questions, and your staff is really awesome and knows those rules as well. Okay, I think we're ready to move to the next.
Real quick, does anyone need to take a quick 5-minute bio break? We've got about 20 minutes left of content, but if everybody wants to power through, we'll move forward. Okay, we're going to keep going. So we're going to move now on to the Conflict of Interest Code and Form 700 filers. So what is the Conflict of Interest Code? Per the Political Reform Act, it requires local government agencies to adopt a code that designates disclosure requirements for designated officials in positions that make, participate in the making, or attempt to influence a decision of the local government. Ultimately, it's not using your position for your own financial gain. So every 2 years, the City of Santa Rosa designates positions in disclosure categories and amends as staff identifies necessary changes our Conflict of Interest Code. The FPPC requires that these Form 700 filers, as designated in our Conflict of Interest Code, file a Form 700 to disclose any conflicts.
Okay, there are multiple different types of conflict of interest laws. They somewhat overlap, but we have to make sure that we are in compliance with all of them. And so first, there's the Political Reform Act that Dina just mentioned. There's also Government Code Section 1090, and you'll hear that as just 1090. And it sounds like we're all playing police chief when we are talking about our 1090 problem, but it has nothing to do with the chief or the police. And then there's common law conflict, or some call it a common law bias, which is a judicially created rule that is much more narrow. So we just need to make sure that we don't trip on any of these. And so sometimes as you navigate, typically if there are some concerns, your city attorney will be brought in. But typically you may feel like, wait, you just said I didn't have a conflict and now you're saying I do. And it's really because we're trying to check the box on each of these 3 buckets. And I just want to say that these are laws, right? The law sets truly the floor, the minimum requirements that you have to comply with. You are welcome to set higher standards for yourself if you feel like I'm not comfortable, I'm just not comfortable, even though the city attorney said I can participate, I don't have a legal conflict. If you can recuse out of an abundance of caution, or it just feels like there's a little bit of a tug here for me and I'm not comfortable with that situation. So really what we're talking about is the floor, not the ceiling, for establishing what is ethical conduct. Okay, so under the Political Reform Act, that's embodied in Government Code Section 81,000 et sec, and it really prohibits commissioners, board members, and council members from being financially interested in decisions of the body. A commissioner with a financial interest must recuse from the decision and not attempt to influence the decision. And keeping in mind that having a conflict is not a statement about, it's not a character flaw. It's not a statement about your character. All of us, myself included, have conflicts. It's just, you all live in this community, you are doing work in this community, and so conflicts will arise. So please remember that this is, again, it's not a statement about your character. It's about whether you would have that tug, whether you feel it or not, whether you agree with it or not. The law has really defined circumstances where we don't want to put you all in the position of ever feeling that tug. And so we have to go through the analysis. A lot of it is very regulatory. Some of it may feel like common sense. Some of it may feel way, way far away from common sense, but very regulatory. We go through the analysis, we can give you an answer. And so just understand that we didn't make up the rules. We just try to help interpret them and help it make sure that you all are complying with the rules that the legislature, the FPPC, and the courts have imposed upon you. Okay, under the Political Reform Act, the basic rule is that no public official shall participate in making, or in any way attempt to use the official's position to influence a government decision if the official knows or has reason to know that the official has a financial interest in the decision. That's quite a mouthful. An official has a disqualifying financial interest if it's reasonably foreseeable that the decision will have a material financial effect on one or more of the official's financial interests. And so there's a lot there. There are a lot of regulations. Some key elements is it a public official? Is there a financial interest? Is it reasonably foreseeable? And is the financial effect material? And there are exceptions. So we go through all the way through the analysis, and then we get to is there an exception that would apply? So these are just broad buckets. You will not be an expert on navigating all the conflicts. I don't get to put my folks out of business quite that easy, right? And so this is a little bit of an issue spotting exercise for you, but truly, if you think you have a conflict, we need you to reach out to us so we can help figure out whether or not you really do. So what are the types of financial interests? It's any business entity in which the public official has an investment of $2,000 or more. It's any real property interest in which the public official has an interest of $2,000 or more. There are sources of income of $500 or more received by the public official within the 12 months before the decision is made. So if you're making a decision on March 1st, we roll back 12 months from that period of time. Please note that your disclosure requirements on your Form 700 are a different period of time. So disclosures don't necessarily match up with conflicts. Disclosures are just that. It's an ability for the public to see what your interests are, but your actual conflicts are determined by a different set of rules. Any business entity in which a public official is a director, officer, partner, trustee, manager, or employee. Any source of gifts totaling, and this number changes every 2 years. This year, January 1, it got bumped up to $630 or more, received or promised, again, within the 12 months prior to the decision. Again, it rolls back from the date of the decision. It's an official's personal financial interests, and it could be the financial interests of the official's spouse or dependent children. So when is a financial effect material? There are lots of regulations. We have to go through the regulations. It depends on what type of financial interest. So I'm going to talk about a really common one, and that is for real property interests where there is a project going on that is located close or reasonably close to property owned by the official. And the FPPC has come up with some bright line guidelines. If it is within 500 feet, you are presumed to have, it's presumed to be a material financial interest unless it falls within an exception. If the project is more than 1,000 feet, there's a presumption that it's not material. These presumptions can be rebutted, so we need a little more facts. And then if it falls between the 500 and the 1,000, it depends, which of course is my favorite answer. It will depend on the development's interest. It depends on how the development will affect the value of the property. It depends on the development potential, the income producing potential, the highest and best use, the character, the market value. It's all the things you probably think. That's where we have to do a little bit of a deeper dive for you. Please note that if you are a renter rather than owning your own home, there's a different set of rules that apply. And if you're on just a month-to-month lease, you are exempt from this rule entirely. Okay, disqualification when you have a conflict of interest. So obviously, I've just hit a few highlights. They're exceptions. They're different prongs. We would help you walk through them. But if it's determined that you need to disqualify, here's what you need to do. You have to publicly identify the financial interest that gives rise to the conflict. I own a home that is close to the property. You you have to identify what your financial interest is and just a little bit about why there is something. It usually is 1 to 2 sentences. We can help you craft that if you're not sure how to disclose it. You then need to recuse, and that means you have to not only participate in the decision-making, but you can't attempt to influence your colleagues. You can't really talk to staff about it. You can certainly talk to staff about when is that item coming so you know when it's coming. But really, in terms of attempting to influence a decision one way or the other. And then you do need to leave the dais. You need to leave the room. There is an exception if it's an item on the consent calendar and it stays on consent calendar, then you can stay at the dais, but we still need you to do to recuse and disclose the financial interest. Okay, now Section 1090. Section 1090 is a different kind of interest. And so just keep in mind that if there's an interest that applies for Section 1090, we also need to do the analysis under the Political Reform Act. So this is where we're overlapping, right? You have different additional requirements. Section 1090 comes into play when we are talking about contracts. It could be an amendment to a contract or it could be the original contract, but decisions about to either enter into a contract or to amend a contract. Essentially prohibits public officials, commissioners or council members from being financially interested in contracts that they are being interested in contracts for the government entity. If a commissioner has a financial interest in the contract approved by the authority, then the contract is prohibited. You have to not be involved in the making of the contract. And so if there's a contract that's coming up, depending on what your position is, what the breadth of the requirement is, there are lots of exceptions to this rule. What I've given you is the general rule for Section 1090, but there are lots of exceptions. Some of the exceptions allow you to recuse, disclose the conflict, and then the body can go ahead and move forward. Other types define it as a non-interest, and so there's not a problem, but you still need to disclose. And so really, if you have an interest in a conflict, in a contract that is coming forward to your body, we would need to talk offline about what role you can play and whether this is a contract that the city can even enter into to begin with, even if you play no role. So again, this is a little bit of an issue spotting exercise for all of you. You're not going to be a Section 1090 expert. I'm sure you'd love to be, and it's very fascinating work. But please reach out if you have concerns with any contracts. And then I touched upon the common law conflicts or common law bias. This is, again, a doctrine created by the courts. It really is If you have a significant personal interest that isn't financial, this would come into play. So if you have a strong bias against, for example, an applicant, this has been your arch nemesis since you were 6. This is probably a time to recuse. If you feel you cannot make a fair and impartial decision based on the facts, this person is your best friend in the whole world. This is probably not the time for you to be sitting and making a decision. Also, this comes into play for those of you who sit as members of a board of directors on a nonprofit, so you're not getting paid. But there would be an obligation to recuse under this doctrine because you owe a duty of loyalty to the city based on your role as a board and commission member, but you also owe a potentially conflicting duty of loyalty to the nonprofit. So that's also an area where this would come up. So again, reach out to us if you have any questions. And then finally, in addition to our office, I think I've probably said it 6 times now in the past 3 minutes, reach out to our office, but please reach out to our office if you have any questions about conflicts. We can help you seek advice from the FPPC. If it is not clear, there's an informal process, there's a formal process. We can talk through with you what that looks like. The FPPC also is available to answer some questions, and we've given some information here as well.
So along with all of those conflict of interest concepts, the Fair Political Practices Commission, or the FPPC, requires a Form 700s to be filed, which is just a disclosure statement or a statement of economic interest. On the list here, you can see which boards and commissions are required to be Form 700 filers. City Council, Planning Commission, and a handful of staff have to file on the FPPC's portal. They're known as 87200 filers. We use a portal called NetFile. You can see if your department or your board or commission is a filer or is a filing board here. We also have a copy of our conflict of interest code that lists out which boards are filers, as well as the disclosure categories, so you know what level you have to report on. We have 3 different disclosure categories, and on the back of the page, it tells you, do you need to disclose your property or your spouse's income? You have to use that document, those disclosure categories. The city clerk's office and the city attorney's office, unfortunately, per FPPC regulations, are not allowed to provide advice on what you should be disclosing. So when you have a question, refer to your Form 700 instructions. The FPPC website, and it has a whole Form 700 pamphlet. It's verbose. It's probably a 50 or 60 page document that steps you through every section of the Form 700 and every schedule. When that isn't enough, you can contact the advice line at the FPPC. Let's see here. Do you really need to file? Yes, you do. Sorry, it's a requirement. So read through the code and get an understanding of it. We're not allowed to provide advice, so contact the FPPC where needed. And the consequences of not filing by the April 1 deadline. So every year you are required to file an annual filing. When you first assume your office as a board or commissioner, you have an assuming office. You have an annual requirement that is due by April 1st. I'm sure you've received several notices already from NetFile, from my office. And then as you leave your office, you will have a requirement of a leaving office statement within 30 days of your exit. So keep that in mind, that the recording secretary in the city clerk's office will be reaching out to you if you finished your term or you're leaving the city and you're no longer able to serve as a board or commissioner. We'll be reaching out for you to file your leaving office statement. So the penalties are up to $100 penalties for late filers, a referral to the FPPC, which they will then actively pursue you to file. And then if you don't file, there's a potential for removal from a board or commission.
And I'm just going to repeat something I said before. So the the disclosure requirements for Form 700 are very clear. They're very clearly prescribed. A large cup of coffee is recommended. But if you go through, that's a disclosure requirement. Not everything that you write on there will necessarily be a conflict, but it's a good place to start to think about it. In addition, your conflicts are not defined either way by what you write on that disclosure requirement. There are regulations very clearly what we have to look at. So the disclosure requirement is kind of a starting place for us to look at. But just because you have to write it on there doesn't necessarily mean the answer will be every time this will be a conflict. It could be the case depending on what it is. There are also, again, exceptions that apply. So when we are looking at conflicts, we are looking at a case-by-case basis. There are certain things on there. So there are certain items on there that are pretty clearly going to be a conflict for you, and you probably can think through what some of them might be. But there may be others that won't be. So it's important not to think that just because it wasn't required to be disclosed on my Form 700, it couldn't be a basis for a conflict, and vice versa. So those are, it's really, they're trying to work together, but they're not exactly the same things.
Okay, so now we're on to the hypotheticals and other helpful tips and reminders section of the presentation. We're close to wrapping up. And many of these we've already hit throughout earlier in the presentation, but we just wanted to hit them one more time so they're fresh as you leave.
Okay, the first one is a member of the public is speaking on a topic not on the agenda. Is that okay? Well, if it's under the time for non-agenda matters, then it's fine. Members of the public can speak about any item within the subject matter jurisdiction of your board. But if it's not under that item, and it's not within the subject matter jurisdiction of the board, so we're not on that item, it's not the item you're dealing with, the chair can direct the public commenter accordingly and stop the comment. So with that, what does that look like? I'm sorry, Mr. Smith, we have open public comment later in the agenda, but we are now dealing with agenda item 3, which is X. Usually the person will say, oh, I'm sorry, I was confused. And so really trying to limit that. Or someone comes to the Planning Commission and wants to complain about our water rates. Obviously, that's not within the subject matter jurisdiction of the Planning Commission. We would redirect, and the chair could stop and say, this is the Planning Commission. I think you probably want to go attend a BPU meeting or a city council meeting. And so we are here, we're the Planning Commission. We don't do anything with water rates. That's what that might look like. Hypothetical number 2, a member of the board starts a back and forth with someone providing public comment. Is this acceptable? No, the public comment period, as we talked before, is an opportunity for the public to speak. It's really a one-way communication. Not only are board members not obligated to answer the question, depending on if the item is even listed on your agenda, if you go too far down with the back and forth, you could arguably get into a Brown Act problem. It will also lengthen your meeting, as we talked about. It may make others feel like they can't give public comment because they don't want to participate in a back and forth like that. It's okay to ask staff for a very brief follow-up, but it needs to be really brief, or just a brief question about that public comment. But really, it is time for members of the public to provide you as a board member with their point of view, what they want to say, not the opposite of that. Again, we want to maintain a level of formality. It's not really just a chat back and forth. So really remember what the role is and what public comment is for. And then, adoption of Rosenberg's Rules and Order establishes procedures and, under those as well. So you can hang your hat on, really the chair can say, public comment is really a time for speakers to communicate with the board or commission. It's not really a time for board members to respond back. And so explaining those rules, if you have a member of the public that's asking, like, hey, can you tell me about this and why aren't you answering my question, to really explain the process to the member of the public, and usually people understand at that point. There's also an ability to, maybe staff can speak with you offline, and then there's a person who can then provide a little more information to that member of the public if they're really just looking for information.
Only 3 members of a 7-member body is present. Can the meeting move forward? No. No quorum, no meeting. Adjourn the meeting. You cannot hear or proceed with any items on your agenda, even if there is no action being taken, not just a little roundtable discussion, not just time to have a quick staff briefing. No.
So let's say you don't have 7 members, it's only 6 members. So would you be able to vote for 4 members if you only have 6 people that have been appointed?
So if you have 6 members of a 7-member body, your quorum requirements still remain 4. And so if you have a item that needs 4 affirmative votes, if somebody dissents, and it's a split vote, the motion fails. If you do 3 and 3. Your quorum requirement still stands as 4, even though your you've only got 6 currently seated board members.
So this goes back to the 700 form. If you are on a committee, not mentioned on the slide, but approve the budgets of an agency or nonprofit in which you sit on the board of the nonprofit or employed, will you have to file a 700 or recuse yourself from approval of the budget? How about if you and I talk offline?
So what happens if you're chair, or as the chair, you skip an agenda item? It happens. You're hustling through a meeting, or you're tired and you just want to wrap things up. Per Council Manual Procedures and Protocol Section 1, failure to observe rules of order. Rules are deemed to be procedure only, and failure to observe such rules shall not affect the jurisdiction of the body or invalidate any action at a meeting that is otherwise held in conformity with the law. The short answer is circle back to it. It's okay. These things happen.
And I will say the chair does have discretion to reorder the agenda. And so it could be that the chair did it on purpose. And so that's within the chair's discretion. There is a process, as always, to overrule the chair that requires a majority vote. That's in Rosenberg's, but most of the time we don't worry about things like that. Chair has the ability to move things around in a way that makes sense. But I think if you think the chair has accidentally skipped the item, you can certainly ask to be recognized and say, I think we skipped item 2.
So next scenario, the chair did not allow for public comment. Any member of your board or commission, or your recording secretary, your seated city council, or city attorney council can respectfully redirect the chair to take public comment. Generally, the public, if they're present at a meeting, they will pop up and say, hey, I want to speak on this item, and the chair will open up public comment period.
And I will just add, it's important that if it's an action item, that you take the public comment before you take action. If it's an informational item, you just have to do it. But you want to make sure that you take your public comment. In the world in which no one catches it until after you made your motion, then you take your public comment and you redo your motion. That fixes it. Please fix it. Okay, the next one. Oh no, my ability to take public comment through Zoom went down. What do I do? If your Zoom connection went down and your agenda was published saying that you're going to have a Zoom connection, that means that you need to take a recess until you get it reconnected. If that's not going to work, then you need to adjourn the meeting, because members of the public have now relied on the fact that you were going to allow for Zoom public comment. And so they may not have come here, and they may have stayed at home and decided to give their comment remotely. So just keep that in mind. If the issue can be resolved quickly, an adjournment would seem not appropriate. So I would try to give staff time to see if they can get it back up online. Just to be clear, if a member sitting at home loses their connection, their internet connection, it's not us, our meeting, our Zoom is working, but a member at home loses their internet connection, that rule doesn't apply. So we continue, and even if you're getting a message from someone, or someone comes in and says, I lost my internet connection at home, I can't believe you continued with us, that is really part of the risk a member of the public takes if they choose to give public comment at home during a meeting where we're allowing public comment at home. Yes. Yes, you can. That said, we need to be able to record our meetings. So I'm assuming that we're still recording, we're just not Zooming.
It depends on the facility of where your meeting is being held. We have a secondary backup recording here in council chamber for any boards and commissions that are happening out of here. We record via Zoom, and we record through our agenda management system. If you are a board or commission that is operating off-site and you only have your Zoom meeting and your agenda states that you will be taking public comment via Zoom, then you have to recess the meeting to see if you can get your Zoom back online. Zoom, generally speaking, is no longer an option for most boards and commissions for public comment. So if the Zoom goes down, as Teresa said, that's the delineation, is if you agendize your meeting with the Zoom credential and public comment to be taken via Zoom, then you have to reconsider whether or not the meeting can go forward. That's one of the determinative factors. Does that make sense?
And then I just want to circle back to AB 2449. So if we go back, we talked about remote participation. There's the traditional Brown Act, which is the posted on the agenda. You have to tell the world where you're vacationing and where your hotel is, et cetera, et cetera. I'm not talking about that. I'm talking about AB 2449. And that's where, for certain need-based reasons, you have a limited ability to participate remotely as a member of a board or commission. One of the requirements is that if anyone triggers the ability to participate under AB 2449, they can only do so if we provide remote public comment ability for members of the public. So you'll see on most of your agendas, it will say if a member participates under AB 2449, we will then allow remote public comment. If you've triggered that, so you have a member that's participating under AB 2449, and we've now triggered remote public comment, we can't go back for that meeting. So what that means is, because members of the public will have potentially relied on that, maybe somebody left who was going to be here on item 6 and saw, wow, we're doing this Zoom, I'm going to go home and be able to eat my dinner and put on my slippers and give public comment. This is awesome. They drive home. And now we lose our connection. What now? So once you've triggered it, and you're providing it, then you have to kind of see it through to the end of the meeting. So just keep that in mind if you're a commission secretary, but also keep that in mind if you are a board member seeking to participate under AB 2449. We are then committing to allow remote public comment for the rest of that particular meeting. Well, we have a bigger problem. Under AB 2449, you have to have a quorum in the room present. So you will never have you should never have a circumstance where someone is, your like last essential person you need for a quorum is participating under 2449 because you needed to have minimally a quorum in the room. So for a 7-member body, that means 4 have to be physically in the room, and then you can have a 5th participate under AB 2449. There's a little bit of a different rule for the traditional Brown Act posting. It's not that rule. I think there's often a difference between what, may be best practices and what is the bare minimum legal requirement. So I think for the most part here, our practice is generally that public comment typically will come after the staff report for most boards and commissions. There is some leeway with the chair. I agree that typically the public comment will probably benefit from hearing the staff report. But in terms of, baseline legal requirements, this is not a legal issue. This is more a practical issue and best practices.
Okay, just some tips for onboarding a new chair or vice chair. Staff should be reviewing with you the role of a chair as a meeting facilitator. So thank you all for coming tonight or this afternoon. I hope you benefited from it. And then as a new chair or vice chair, make sure you are getting familiar again with the Brown Act, Rosenberg's Rules of Order, and any bylaws that may deviate from Rosenberg's Rules of Order. Rosenberg himself recorded a Rosenberg's Rules of Order training. If you just Google Rosenberg's Rules of Order, you can find it's like a 1-hour video that covers basically what we covered in just a little bit more detail. And then your bylaws, there should be on your board or your commission's website. If you can't track them down, ask your recording secretary or your staff liaison to get a real understanding of what the scope of your board or commission is. So this is Teresa. We're wrapping up. This is like the last slide.
I'm going to talk really fast. Okay, multiple motions on the floor. You guys know all of this one. We already put the answer up. Okay, last one goes first, right? Multiple motions on the floor. LIFO, last one goes first, right? All right.
So lastly, we just want to share the link to the reference materials. This presentation will be made available online later this week or next week. Hopefully, so this presentation document, as well as the video, so long as we didn't have any technology failures. And thank you very much for coming. If you have any questions that you aren't comfortable raising your hand and asking now, I'm going to hang out. I think Teresa's going to hang out for a few minutes, and we're happy to ask any questions offline. Thank you.
Thank you very much for coming.